So we're back to you with In Your Best Interest here today with Michael Rousseau, continuing from our previous podcast where you got to know him, got to know a little bit about one of our attorneys who I think is one of the best attorneys in the courtroom that I've been around. And wanted to kind of do some of the rapid fire Q&A sessions that we get because I think a lot of people have the same questions, and we have Q&A places on our blog. We have Q&A portions on our website. We've spent time doing the rapid fire, but we still get the same questions over and over. So as much as we can put this out there for people that are going through some serious issues, this is totally on the fly, so not rehearsed. And I want it to be that way because I think it really does answer that there are no dumb questions in family law. And sometimes people think that, well, I don't want to ask my attorney this because this is just really is an unintelligent question or it's too simple for them to deal with. Mm-hmm. So I'll just dive right into it. So one of the questions we get a lot is, well, what about like a legal separation in Texas? We're not really ready to file for divorce. My wife or my husband and I are not getting along, but what do we do immediately? And is there some documentation that we can protect ourselves with? So I want to dive right into that. So what are your thoughts on that question about legal separation in Texas, and how do you deal with that with clients?
Well, in Texas, there is in Texas Family Code, no such thing as separation or legal separation. And when clients say, "Oh, I've been separated for," we've been separated for how many years? I mean, according to law, you're still married. You're married till your divorce, and until you file for divorce, there is no such thing as separation. And so telling clients that if you can move out, if there's no court orders in place, you can do whatever you can do whatever you want with your bank accounts. It might come back to haunt you. It might come back for claims against you, but there's nothing preventing that. So just telling clients that separation is not a thing in Texas. It's in Texas family law, and the only way you will be considered legally separated is once you're divorced.
Yeah, and the other thing I get questions on a lot are about like postnuptial agreements, prenuptial agreements, obviously before the marriage, but postnuptial agreements being agreements after the marriage, and then a lot more frequently because of our common law marriage, which basically, for those listening who don't know what common law marriage is, it's living together, holding yourself out as husband and wife for the 2 years preceding the lawsuit, and we get quite a bit of those. I think I'm married because we either are because we filed joint tax returns and we agreed to be married and all those things, or I just think we're married because we live together. So I want to break down those two agreements. So what is significant in your mind about a cohabitation agreement, and how have you dealt with that specifically?
They're quite rare, the cohabitation agreements in family law, and the cohabitation agreements are generally used to where a couple are romantically involved with one another and they don't want to be legally married, but because of common law marriage in Texas, I mean, you could be we're one of the few states that have that. Most states.
What are your thoughts on common law, first of all?
I mean, it's such a difficult thing to deal with when it happens, and it's rare when they try to proceed with the divorce under that because it's so fact intensive. But you have to prove. I mean, the two main things are you hold yourself out to the public as husband and wife, and you all reside together as such, and all the factors that you just mentioned about. Filing joint taxes or changing your last name or having an actual ceremony but never filing a certificate, those can come into play to prove it.
They should make sure they tell us about those things, right?
Yes. And I've only had it, and like I said, it's more rare now, but Texas is one of the few states that have it. So, and that could come back to bite you if, you get the engagement ring and you all just, act as if you are married, but never legally get the marriage certificate. You could find yourself in that situation.
Yeah, and the cohabitation agreement, I was always kind of like, is this overkill? Like, do you really need this cohabitation agreement? I've started looking at other states that have massive common law disputes that ended up all the way to the Court of Appeals. Because again, for our listeners, they don't understand, like, most cases, even if you're right on the law and a judge makes the wrong decision, the parties don't have the financial ability to take it all the way up to the Court of Appeals. So you're getting like a lot more financially affluent cases that have the ability to do that. But in the cohabitation agreements and those specific big asset, high net worth cases, they did have massive impact because they had very clear language that we are not married. And to me, it was surprising that they even got to the point of past summary judgment, or where the court could make a decision without, basically getting all the way to the trial stage with that agreement. And, I am starting to see a lot tighter cohabitation agreements and the impact certainly that they could have. But I want to touch more so on the postnuptial agreement, because I think we get those questions more than the cohabitation agreement. So describe to our listeners what a postnuptial agreement is.
A postnuptial agreement is essentially what most people are more familiar with, a prenuptial agreement, but it's an agreement post-nuptials, post-marriage, of where you are agreeing that in the event of a divorce, after you have been married, that if we get divorced, that we will divide our assets and liabilities in a certain manner. Basically, which could be in contradiction to community property laws of Texas. It could be, we're married, but if we get divorced, you can keep the home, and all the money in these bank accounts that I make, my income will be my separate property instead of community property. And postnups, our firm's dealt with numerous of them. I've dealt with a couple of them too. I think they're more rare than prenups because you're already married, and I think when people face that situation, it maybe is because they think they're leading to divorce.
Yeah,
and because of that, generally one party wants one, the other doesn't want to do it. And then, a prenup or a postnup, it's not just you go to your spouse and say, I want all this can be mine, you get nothing. It's a negotiation. You're going to have to give something up, probably to get something in return, and oftentimes they won't sign them.
Yeah, and one of the things that I think people forget about postnuptial agreements is they don't require consideration. So like in a contract in Texas, consideration means if I do this, you pay me this, the payment for the services is the consideration. But in a postnuptial agreement, usually it's somebody that steps out on the marriage or has done something really bad, and they're trying to reconcile, and they're making a bunch of promises. And I really struggle with them, because if we're drafting the postnup for somebody who's done something really wrong, usually like somebody's trying to put the screws to them.
Yeah.
Right.
And that's what the last postnup that I did was because, and they got divorced afterwards, was because the wife was having an affair with her husband's best man at his wedding, and she felt horrible about it. And she was saying, look, we get divorced, you can have essentially everything. And she had her parents, her lawyer, everyone advising her, do not sign this thing. Adultery is not, it's a grounds for divorce, but it's not going to effectively
do 100%.
Yeah, you're going to get probably this close to a 50. There's no children involved, 50-50, close to an equitable split anyways. But she signed it.
And there was no wasting in that case, like meaning that there wasn't a bunch of expenditures.
The post-up was essentially a apology for ruining this marriage. And I don't know if it was out of emotion or just their agreements or a way of reconciling where she felt she hurt our client, but they signed it. But like I said, a lot of people don't feel that way, and they feel sometimes that their actions were justified. And when you have a lawyer and your family and friends and pressure, do not sign this thing, they could fall apart. And it's also important to note, I think on any kind of prenuptial or postnuptial agreement, it does not apply to custody. It's void. Legislator has indicated you cannot do that. And which makes sense. You can't say, well, if you get divorced, you get primary and I'll just have weekends. Yeah. You don't know. By the time you get to divorce, that person you agreed to have primary and all of this with the children is a drug addict at that time, or an alcoholic, or has committed family violence. So you can't prenup kid issues. But sometimes I think it's helpful to do it for property issues, because at minimum, you have a peace of mind throughout your marriage. There's not that looming anxiety that, well, we're going to get divorced and I'm going to lose this, or she's going to take that, or he's going to take everything here. It's already been it's already been figured out. So you can focus actually more so on resolving your issues without the uncertainty or suspicion of that there's some financial motive behind it.
Yeah, and the other thing too is if there's a significant amount of property, I mean, you've got to have a very complex inventory process to really make sure that you're gathering or capturing all the things that need to be in the postnup. Specifically, if you're partitioning property or you're giving property to the other person in the event of a divorce. And so I kind of headed off, and I wanted to hear your thoughts. I kind of headed off with, listen, if you're going to go through the postnup process, it's not dissimilar to the divorce process as far as cost, time, disclosures.
Well, you have to give financial disclosures of all of your assets. Both sides do. Otherwise, if you withhold, a bank account or investment account or an inheritance and don't provide that information, disclose it to the other side, that could void your.
Well, and it's an undivided asset either way, too, right? So,
even worse, it could just, if the court says that you didn't follow prenups and postnups require very strict procedures to keep them enforceable. I mean, I even recommend, I know it could be more expensive, but to have a court reporter at the prenup or postnup signing. Yeah. So it's on a record that they're not under duress, they understand, they've received full disclosure, they understand exactly what they're signing, what they're agreeing to, what they're giving up potentially. And it could be an expensive process too, but it potentially can make the divorce streamlined, quicker. Maybe not. It depends if there's children involved.
Yeah.
And then who knows?
No, and that's a great point because the last couple we've done, it's usually like some of the family members that have a very significant estate and their children are getting married and they're concerned about business interests and whatnot. And, there's also kids that are coming in, and then the children that are getting married, they're like, I don't want to go through all this. And so it's a pretty you need some significant runway in my mind before you do a pre or post nup. And a lot of times if somebody's a bad actor, they kind of flare up again before we even get past the negotiation phase. And then they're like, okay, well, let's move forward for divorce. Right. So, not to say that they're not good documents and they are not very helpful. It's just, I want clients to be aware of how much time and energy and effort that goes into that preparation. So next question, can you get a divorce in Texas if your spouse lives in another state? And I want to touch on this one because you and I have tried cases together where there's jurisdictional state issues and which state the case should be filed in and which county and whatnot. So let's touch on the first question that our viewers have asked. So can you get a divorce in Texas if your spouse lives in another state?
Yes.
And Texas operates under that first to file in the state where the party has resided for 6 months in the state and 90 days in the county. But we represent athletes and various people that have multiple homes. How in the last couple of cases that you and I have dealt with jurisdictional issues, have you seen the court deal with where they intend to permanently reside?
Well, you have to, if you want to file in Texas, you have to meet the jurisdictional requirements. You said you have to be in the state for 6 months and with the intent to make it your residence. This becomes issues where people travel a lot for work or they have work assignments. It wasn't a permanent place of abode, and it was...
Hell, we've had an RV before.
Yeah, I mean, if it's the domicile, yeah. I mean, I guess if you're living under a bridge in Texas, that's your domicile, you can file here. And then which county? What becomes difficult is where they haven't really resided somewhere for 6 consecutive months. And there's case law, and we can navigate that and fact specific. And it's also, yes, there's other issues you could face if you're a resident of Texas, but your spouse is not. Yes, you can file in Texas. The court can grant your divorce. If they don't have personal jurisdiction over, which is more of a complex issue, over the other party, it might lead to some potential issues with your divorce. The court will grant a divorce eventually, but it could have issues with enforcing child support or the sale of property, especially if it's property overseas. But generally, people will work that out in mediation to avoid those issues. But you also have to take into consideration if there's custody involved, where the children have been residing the last 6 months as well. So just because
we just had the case with the child that was very young and before the 90 days could even kick in.
Yeah, and that happens too. And they've moved from Texas to Oklahoma with the parents, and then the mom comes back to Texas with the kid. And there's case law where if there is no continuous 6-month jurisdiction, generally you could file, if that's where you're intending for the child to reside. And multiple states could have jurisdiction over that point. It becomes which state wants to take it.
Yeah, I wanted to get your thoughts on this to segue into this question. So I get the question a lot, does it matter who files first? And I don't like when I hear attorneys say it doesn't matter, because to me, and I wanted to hear what you feel, as far as being able to talk first and present the evidence first, that's an advantage. If you've got dueling jurisdictions and dueling venues where it could be proper in either place, that could be an issue for proximity of where your client lives, where the witnesses are, and just cutting down costs of travel and all that other fun stuff that clients have to deal with. So to me, it very much is the answer that it depends, but it usually does matter. What are your thoughts on that?
Well, certainly for jurisdictional or venue issues, it matters for sure, absolutely, because you want to be able to litigate the case where you're closer to. It could just be, especially from a venue perspective, I mean, it matters.
Not only that, like if they go file in another venue and you've got to go do a motion to transfer a venue and you've got to do controverting affidavits and all the things that you have to...
It's just more procedural work. It's going to be more expensive. If your spouse goes from Tarrant and says we're breaking up and moves over to Dallas and files right then, and they've been there 90 days, y'all been separated, not legally, but not living together for 3 months, and now they just file in Dallas County, but you're like everything's in Tarrant County. That's where I am. I mean, Dallas County technically has proper venue on that. Yeah. So now you have to litigate across town. It might not end up being the biggest deal in the world, but it certainly is an initial disadvantage. And then even when you said previously about filing, who files first, who's the petitioner, who's the respondent, getting your story out first. If you're the petitioner, you go first in all the hearings, including trial, to present your case in chief. But I tell clients that just because the other party filed first doesn't mean your case is over.
That's
or
right.
that it's going to, it's putting you in a complete disadvantage where you can't move forward. And sometimes I think in certain cases it can be advantageous, even if the other side files first, because they put on their case in chief first, but then it gives us the opportunity to know what they've said, and it's easier for cross-examination sometime.
Yeah, I don't think some of our listeners understand that when we get into a case, it's very much trial by fire in the first 2 or 3 weeks. Like, we're not going to have all the facts. We're not going to have all the evidence. There's going to be some he said, she said. There's going to be some hearsay or objections to evidence getting in a courtroom. And I just think it's important to remember exactly what you just said. Like, the timing and order and structure really depends. Mm-hmm. You're not going to lose a ton of ground, but if I had a perfect scenario where two parties, we don't represent Jesus, as we say, two parties have some bad facts, I'd rather get on the front end of that and present first.
Yes, and I'm a huge proponent from a litigation strategy, and I always ask clients, and most are honest, some just don't bring it up or are hoping the other side wouldn't know. You have to let us know. And it's not from a judgmental standpoint. I really have I'm not judgmental. I understand people do crazy things. I'm not fazed literally by anything. So, but we need to know it for two reasons. One, I don't want to put on this case where we're selling you as a perfect parent, and then there's all these horrible things that are going to be said about you because it makes our case look weak. It makes it look like you weren't honest. And more importantly, I like, what are the 4 or 5 bad things they're going to say you've done? That not just a he said, she said, but they have a picture of this, recording of that. I did this. It's better to be able to go first and get out in front of that and say, and almost where you're telling the judge, I'm not perfect. I've done this, but I can explain it, because it defeats all the ammunition they think they're going to have when they cross-examine you, because you already just admitted to it and you got out before it. It's better just to tell the truth and get caught for withholding it.
Yeah, we were you and I were in trial not too long ago, and as you'll recall, what did our client do to the house whenever she left?
Oh, I mean, I get it. People, and
this was before representation. But.
Yeah, and the judges, they're people too. And a lot of them have been through these issues, been through divorce, and they understand it can be emotional. And people do things where they go, I I broke the window or slashed my husband's tires, or I turned off the AC, or I cut the electrical cord, or something they just did out of just impulsivity.
Yeah.
And it's better to just bring that up and explain why you did that and why you felt that way, and say, well, instead of getting cut on a cross where it wasn't true you slashed his tires. Yes, and then you're stuck with the yes/no question,
and then it's gone. It passes. The baton is passed to the other side. You can't even really rehabilitate in a lot of situations.
Well, and if you do on a rebuttal, but by the time you get there, it could be another hour later, and the judge has already remembered tire slash.
Yep.
And like, wait, what was your reasoning? It's better to say, and have you? Is there anything that you've done that you regret at this point? Well, yeah, I slashed tires. Well, why'd you do that? Well, I came home and his ex-girlfriend was in my bed. You could get out in front of those with the judge, and it's going to defeat. They can't just re-ask you that question at that point. You've already admitted to what you've done wrong. Granted, there are certain legal reasons to keep things out. Something that's incriminating. We're not going to ever have you incriminate yourself. There's Fifth Amendment still implies, or if there's like a legal reasoning to keep out. Like a lot of times, people will say, "Well, they're going to bring up my DUI from 14 years ago," and we won't bring that up. And if they try to bring it up, there's evidentiary rules of what we can. Exclude that from being admitted to the court.
Yeah, you brought up a great point too, because I was trying to think of some good examples of when you're the counter petitioner, when it would be advantageous. And you and I have both had this case multiple times where one party gets up and it's all about the negatives of the other party, specifically their ability to parent, right? This person's this and this person's that. And the first question I ask on cross is, and usually I don't ask open-ended questions on cross, but what do you like about them as a father? And they're like, they just get stuck.
What's crazy is a lot of people, unless I know for a fact they're going to answer it the way I want them to answer it, I'll try to avoid it. But a lot, cases, what judges I think are looking for, especially from a parenting, is someone not just go up there and say, I'm the best ever, and they suck, or they're terrible, and there's nothing good about them.
Right.
It's not true. You had kids in a family, you've been together for so long. There's some point you saw something. And I think humility on the stand is so difficult to do, and not just on a stand in life, that if you can go up there and say, yeah, I think he's a great father or a great mother, and I think he'll do a great job, but I just know I've been doing these things for the kids every single day. He's never been involved in that yet. Hopefully he gets there. And that's so important, I think, when you go into court or to have that mindset, because judges will you just have more credibility and you seem like a more honest person. And when the other side says, nothing good about them. The court's going to say, well, nothing you're saying is objective. That's just not true. No one's perfect.
Yeah, that's a good segue too to, one of the things that I talk about in consults, and I know you talk about with our clients, is, the courts are looking at what you guys have been doing and how not to disrupt the child's environment. So, when you have somebody that's been the primary caretaker, I get the question a lot. Well, I was only doing that because I was working and they were staying at home. But now that we're going to be separated, they're going to have to work too. How does that impact in your experience with all the cases you've done? What the court does on a temporary basis, as far as like what the court's looking at the history.
Yeah, the court's looking at the history, and they don't want to hear, and they don't have time to hear about, we first met in college and. Sometimes he could come home and yell at me, or she would stay out too late with her friends. They want to hear, here's our kids, here's their ages, this is where they're at school, this is their routine. And I like to walk through clients, a day in the life of being the caretaker. What do you do? Who wakes them up? Who gets them ready for school if they're in school? Who puts them down for their nap? Who's making all the meals for them? What are their teachers' names? What involvement do you have with the school? Who's their pediatrician? Who's their dentist? And who gets them to all these appointments? Who does that? And because the court's, like you said, trying to keep a temporary order is they're trying to keep a status quo in as much stability as possible in a completely unstable situation for the children. And they might change their mind moving forward. Things might happen throughout the case, but generally at temporary orders, it's going to be, this is the evidence that we have to present to show within a very short period of time, within the last year or two, and who's been doing all these things, and the courts are inclined to look at it that way.
Yeah, and also too, I love the timeline and chronological order, because when a client comes in and says, well, they were drunk 8 months ago and they're a total alcoholic, but 2 weeks ago I left the child, with that person for a week, or they've been violent with me and I just got back from an intimate vacation with that person. Like, the timing is also critical.
It is. And I know that's extremely difficult on a personal level because, the complexities of marriage or any kind of relationship like that. Yeah. And, and it's almost like getting used. I was trying to be a forgiving husband or a forgiving wife. And yes, they get drunk all the time, or they would do these mean things or that. But
I still love them.
I still love them. And I want to keep the family together, and I forgave them and I move forward. And then unfortunately, they sometimes could be used. You can't then retroactively say when you file, well, like 4 years ago, he came home drunk and fell asleep on the couch.
Yeah.
Or I came home from a work thing, he was drunk on the couch and the kid was crawling around on the floor. I mean, it could be helpful in your case, but it opens the door to saying, well, did you call the police? Did you call CPS?
Yep.
Did anything actually happen? Y'all been in 4 years since? Hasn't happened, right? And you're kind of in a rock and a hard place there, because you don't want to just call your marriage quits right off the bat when something doesn't, if someone screws up, people screw up.
Yeah, there's battered women syndrome. There's battered spouse syndrome. I mean, it's a real thing.
It's a real thing. And there's also, and even in the lighter context, you want to forgive people, and you realize that maybe it wasn't a big deal then, but now you want to make it a big deal. And you have to understand the court's going to say, well, he maybe got drunk 4 years ago and, let the kid run around the house or whatever, but I'm not going to put him on supervised and, submit him to random drug testing for the next until I.
Or the alternative where they have a bunch of really bad stuff happen and they don't acknowledge how serious it is. Oh, I don't want to go and, I want 50-50 when somebody has been abusive and verbally and emotionally and physically and has alcohol and drug issues. And then they go, well, I'm going to get all this out there, but I just want to go for 50-50. Like, I'm like, that sandwich doesn't taste good.
Yeah, you can.
The punishment's got to fit
exactly.
the crime. Yeah,
you can concede, I think, on a lot of things that you've done wrong or that they've done wrong, and you still have to take a position that you believe is in your children's best interest. That I don't think that removing this parent from their life is in our children's best interest. I think our kids love both of us and want to be with both of us, but I got to look out for the safety of our kids, and that's why there's so many different injunctions and certain orders courts could put in place where. We see in family court, such as supervision, drug testing, counseling, requirements, step-ups, possession schedules. And I think advising a client that just because you're seeking these things, don't feel bad about it. Unless you're doing it when it's unnecessary, at which point we'll advise you that this is not
vindictive,
vindictive, and it's not going to work. But you're doing this because you're helping this person succeed and get to where they need to be be a parent on their own.
Well, I'm going to kind of combine these questions because we have a ton of them and we're not going to be able to get to them all today. But can you secretly record your spouse in Texas to use as evidence in a divorce case? Part A. And part B, if you cheat, do you lose everything in a divorce? And a lot of times we have recording devices where, they're picking up two parties. The reason why I combine those is because they're picking up two parties. They're putting tracking devices and recording devices. And we were just in trial 2 weeks ago where there were some recordings that were very critical to the case. And so first I want to start there. What did the court do when the recordings were inappropriate, or how they got the information was inappropriate? What happens to the evidence?
So to answer the question, can you record, like a video record or phone record?
Yeah, video phone record.
Yes. The short answer is yes. Texas is a one-party state, meaning one party has to know that there's a recording going on. What you can't do is, and I see this sometimes, I heard him talking on the phone about cheating on me. Well, how do you know? I recorded him. Okay, how'd you record? Oh, I
bugged their phone.
No, yeah, or I've left a recording. I left a recording device in their office dresser.
So when we say, just to clarify that, so when we say one party, you have this reasonable expectation of privacy issue, right? And so, like, if you're talking to me and you and I were married, then basically I can record anything you say and use that.
Yeah, I mean,
without telling you, hey, Michael, I've got a recording device.
Exactly.
Here.
If you and your spouse you can have it in your pocket because there's one of the parties to the recorded conversation has to know that the recording is going on. So you're a party, your spouse is a party. If you leave a recording device in their car or in their office or somewhere like that, then there's only one party to the recording, and that's the one party not knowing they're being recorded.
And that's no reasonable expectation.
Exactly. There's potential criminal issues with that. Granted, I don't necessarily know if a family law courts can do it, but it certainly would be excluded from evidence. And two, you can't, if someone has their cell phone and they go to sleep and you saw them type in their password and you grab the phone, enter the password.
Super familiar from trial a couple weeks ago.
And I mean, I could sarcastically say, you're right. This is the first wife or husband, boyfriend, girlfriend has, ever gone through the other's phone.
Ever.
You're right. In a sarcastic tone, yes, it happens all the time, but it can make that evidence inadmissible because you had no authority or consent to go into someone else's phone or into someone else's computer.
To breach that reasonable expectation of privacy.
And there's a criminal component to it potentially. And two, the court will deem it an inadmissible for the court to consider as evidence. So no, you can't do that. But long story short, yes, having a recording in your pocket while you're having a conversation with your spouse or they're acting out around the house and you're recording them, you can certainly do that. But there has to be at least one party to the recording knowing it's being recorded.
Yeah, and I mean, I think that's a great point to talk about the costs that are sometimes associated with getting the evidence. Like, we're not going to have private investigators following people around in drones and all this other stuff. That's not reality for most people's budget in a family law case. No. And so to segue into that next question, which do you get everything if you prove adultery or you prove some fault in the breakup of the marriage? I want to talk a little bit about why sometimes, even though we want to get that evidence, we can't afford to get that evidence, but the impact down the road of what that evidence could be. So with adultery, from our experience, I've had crazy cases where, and I call them the outliers, where we've done 80-20 type splits, but that's a very, very rare situation with massive wasting.
Well, I think for a court to find grant a divorce on fault ground of adultery, if you want to tie that into a disproportionate award of community assets, generally most people, you would have to prove that the cheating spouse was spending a significant amount of community funds on the paramour, buying her or him a car, extravagant dinners and vacations, sending him money. That's where court, and they're not necessarily doing it, the split, because there was adultery. It's because the adultery led to a different cause of action.
And that, it pisses me off from like a moral level because well,
and certainly courts, they view it that way too. I think, I don't want to throw percentages around, but if there's adultery and it's proven and the court's dividing it, most judges will give you a couple points. One where, if instead of, I would have done a 50-50, but I'm going to divide this at 53-47.
Yeah, and I think it's judge specific, county specific. There's a lot of things that go into that. Yes. And then how egregious is it? What I look at all those factors, and I know you do too. We've talked about this a bunch, but I just think that the idea that there's not some set parameter for these percentages can be very confusing, because if you get hurt and somebody rips your family apart, to me, like, you should get a big pound of flesh there, right?
And I agree. And I think a lot of these judges, they agree too, but they have to follow the law.
Yeah.
And they might say, if I could give you 100% of the estate because this cheating while you were home with the kids, he was out just, cheating nonstop, sleeping with a ton of women, gave you well, that'd be different, but a lot of certain issues, but the law requires me to divide this estate in a just and right, fair and equitable division of your estate. And I think it's fair and equitable due to some bad actions to give you a little bit more, but it's not going to, but if I could, I would, but I can't.
So moving to the most important part of what I think we do for a living, the children issues. This question is, can a child testify in a custody trial, and how does it work? I want to front load or give some context with, we get the calls a lot that say, well, my child wants to tell the court this, or my child's voice needs to be heard. And I'm not being condescending the way I'm saying that, but I hear that a lot from people that really are on the brink of losing custody as much as they might think they're helping their case. So talk about what your thoughts are on a child's testimony in a courtroom.
Well, one thing I tell clients is, don't quote your kids, because most of the time they're telling you what you want to hear.
Love it.
And that's because they don't want to disappoint you. Not necessarily because that's really how they feel. and you're putting too much pressure on your kids by trying to build your case based on what they're telling you because they want you to hear that. But in Texas, once a child is 12 years old, if you request to have the court interview the child in chambers based on a preference as to their possession, access, or conservatorship, I mean, the Texas Family Code is statutorily required if you request it, and the court will at some point interview the child about their preference and why they feel that way. It's not a guarantee that just because a child says, and it's a sliding scale, a 12-year-old, what they have to tell the judge might have a lot less impact than what a 17-year-old or a 16-year-old says from a maturity standpoint, or their reasons. They might go say, yeah, I'd rather live with dad because I can stay up late and play video games and have my friends over and I don't have to do my homework and it's more fun. But that's not, just because your kid says, the judge might say, well, that's not in your best interest. And it's just a factor for the court to consider. It's not I must give this child what they said. Very rarely will a child actually testify in court. It has happened. It's not, a lot of courts won't allow it.
It's painful to watch.
It's painful to watch, but it has happened. But a lot of judges don't want to get into that void. If they're under 12, some counties will have family court services interview kids through court service type ordeals or custody evaluations where they are interviewed and then a report's made based on their findings of that. But for the court the child to actually just give a preference and to state that to the judge, they have to be at least 12 years old.
Yeah, and I mean, I get a lot of questions, I know you do too, about these custody evaluations. And, you know, there are some good custody evaluators. There's some bad ones. There's some people that are very diligent, and there's people that are not, and they are very opinionated early on and not. And so I definitely understand why people have had their disagreements or issues with custody evaluations. But I'm like you. I just don't see. I've had probably 5 cases in thousands where somebody has tried to put children on the stand, and it just does not. I've never seen it really go super well for the party offering that child's testimony. And usually with a teenager, it backfires too, because it's the buddy system where you know, Disney dad or Disney mom has buddied up with the child and influenced the child to testify in a certain way. And it's really easy to expose that with a child when you have a skilled lawyer cross-examining them. And we don't have to be mean about it.
No.
We're just like, look, you say that your dad, what school would you be going to over at your dad's house? Well, yeah. I don't know. Well, who would your doctor be, you know, 6 hours away? I don't know. And so it's not a fair position to put children in that position. But
and I would say I've never personally put a child on the stand.
I've never done it either.
I just know it has happened.
I've done it from a corroboration standpoint of or a rebuttal standpoint of something that somebody said happened that did not, but not from a child custody angle. So what's the craziest outcome that you've seen from a pro se or somebody that represents themselves? And this is on the fly, so you may not have some crazy, interesting outcome, but what's the craziest thing you've seen a pro se do or happen to in a courtroom?
I guess from a crazy I mean, just, I guess a pro se try to present their case and ask questions to the other party, and I have a legal objection to everything they say. They can't get a single question in. They can't get a single piece of evidence in. And if they're going against the lawyer and you're pro se, that lawyer, unless you do it correctly or it's like an obvious, like, yeah, it's going to get in, they can object and make all these legal objections to the way you're asking. It's not the questions you want to ask, it's how you're asking them. And I've had pro ses just freeze up on the stand.
It's not easy.
No, it's not.
Even for us, we've done this a long time.
That's the most,
it's hard.
Yes, it is the most, to me, interesting part of being in a courtroom. I like evidence. Some people, I mean, transactional lawyers, I talk to them, they don't even know a single rule of Texas, a rule of evidence. They don't know a single one. They don't need to. But I think it's extremely important because it's how you get evidence before court. And not everything is admissible. So I've had pro ses, they go there and they just want to say hearsay the whole time. Well, my aunt told me this, or my kid told me that, and they can't get it in, and they just have a breakdown in the courtroom because they can't get anything into evidence. And the judge is just said, I can't consider anything you just said.
Yeah, I mean, I've literally represented a client in a past against a pro se where the pro se litigant that didn't have a lawyer. This is not tooting lawyers' horns. This is just the way it is. The pro se litigant was really in the right, but had no idea how to get the evidence in. And I'm sitting there like, I have to defend our client. You know, we're hired to do our job, and we have a legal duty to represent our client and an ethical duty. And, you know, in that case, I walked out of there feeling like, man, I don't even know if I like this case. It's really tough because that guy had some really, really tough evidence that should have come in. But just like you said, he had no idea how to offer it or get it in an admissible form. And so it ended up like where my client actually needed some direction, needed some changes that needed to be made, but couldn't do it because they decided to do that or save a buck. That kind of, we probably should conclude here, but funny stories, anything that you've seen happen in or outside a courtroom that completely derailed a case. I'll head off with about 3 years ago, I'm sitting at counsel table, and all of a sudden a pink sex toy comes flying across the courtroom and it hits my client in the shoulder. And I turn around and the judge is in the courtroom, the bailiff is sitting in there, and I'm like, what in the heck is that? And the guy looks at me and he says, well, you said I had to return her personal property by this day. And that was obviously the first like 5 or 6 questions was, hey, Judge, I don't really know how to say this, but this guy basically assaulted my client by it's not funny, but it's what happened. And, you know, we've seen people slap each other and do crazy stuff at the courtroom. But what if anything, I know clients want to hear some crazy story, and usually it's not as funny as we may think it is when you're in the moment. But what if any funny or wild stories do you have in the world of family law?
I mean, you have, I mean, usually the stories themselves are more wild, but you try to contain it in the courtroom. But I mean, like I said, emotions ran, high during these cases. I mean, that were opposing party, they took a break, the judge off the bench, and they just left, didn't come back, refused to come back. I've had police have to escort people out of the courtroom, arrests made in the courtroom for acting out and screaming at the judge. I've had to separate clients walking out of the courtroom after a ruling. I mean, fortunately, I've never dealt with, the really bad, like someone killed, a suicide or an attempted murder, and those do happen.
Yeah, they've happened at our firm.
Yeah, and
there's no. I don't like that question because there's nothing funny about. I mean, there's nothing funny about any of this stuff, but occasionally there's like they'll draw phallic symbols with lipstick on the windows of their car, their house, and some of this stuff you got to be like, man, this evidence is like really, really stupid.
I've had a case where the husband found out the wife was cheating, and she got home to her car, and there was a picture of her from a PI walking out of this guy's apartment, them two, and he had a buck knife stabbed through her car with it. Like stuff like that, which we moved for a protective order because we thought
by the time that stuff gets to us, then it's not exactly funny anymore.
Exactly, and it's just like
you're going to get in our crosshairs.
I've had this a client where she was supposed to move out, or I represented the guy. She was supposed to move out, and he was going out of town that weekend. His car was parked in the street, and she dumped a box of all of his sex toys and all that kind of stuff. Dumped it on the roof of his car in a nice neighborhood, and that stuff was just sitting. He got home Sunday night, and that for the last 2.5 days, they've just been sitting on his car. I've had people write things on people's cars.
Well, and on a serious note too, we've had cases together where a client overstates their case potentially or pleads a certain way, and then like in a protective order case, they'll show up to court with the other side that they're filing a protective order with, and then we had no idea how they get to court, and then the judge is like, "Wait a minute, you're not afraid?" What And so I don't like to poke light at family law issues. I mean, obviously we can laugh behind the scenes about some dumb stuff, but there's nothing really that funny about this, in my opinion.
No, it's not. It's not really more funny. I think it's more of a context to just tell any listener that if they're feeling overly emotional or they can't believe the way they're acting or feeling that, it's common.
And we've seen I can't think of a scenario when a client tells me it's the first time and my case is so complicated and you're never going to understand this. I mean, I think you and I have seen, I would say, a majority of things people are capable of doing, but I just think it's really important for the family preservation of the kids and all that to just bury all that crap and not make light of these what they questioned are the funny moments, because they're just, hell, we just told you they're not that funny. So anyway, we've got a bunch more questions in the rapid fire segments that we'll get to later on. But again, Mike Rousseau here, awesome attorney that I get to work with on a daily basis, travels all around Dallas, Collin, and contiguous counties, and very good in the courtroom. Not going to talk to you about puppies and cupcakes all the time. He's going to be very blunt and direct. And I love having these different aspects and highlighting our attorneys for what their value is to me when I do the consults, and I recognize that, and those change over time. So if you need to reach us, you can reach us at our office at 817-336-4444, or you can reach us at lawyerdfw.com. We hope these podcasts are helpful. We've got a bunch of information online on our website at lawyerdfw.com if you want to dive into some more of this. So thank you for listening.